We thank you so much for watching Law School Made Easy at Law School Made Easy 256. We want to discuss contract law and we want to discuss the parole evidence rule. This is a very important topic under contract law 1, and we want to appreciate what we mean by parole evidence rule. Remember, we have already agreed that a contract can be made in writing or it can be oral. It can be partly in writing and partly oral. So that is that it can be express terms or implied terms. Those are the forms that a contract can take. But under parole evidence rule, we are saying that under parole evidence rule, the moment parties reduce their terms of a contract into writing, they are bound by the corners of that document, the four corners of the document. The moment parties reduce their terms of a contract into writing, you are bound by the four corners of that document. There is nothing you can add or subtract or to vary or to contradict what you have reduced into writing. That is what we mean by the parole evidence rule. What you have decided, remember we have freedom of contract. You enter into a contract willingly. Now, the moment you decide to reduce that contract into writing, you put down the terms of your contract. What you have just done, you cannot escape from it. You are bound by those writings, by that document. The four corners of the document is what now controls you. So court will look at that and then determine your matter. You remember when we looked at exclusion clauses under signature. Remember we said something similar, that under exclusion clauses, that if you are paid a signature, which we call the Lestrange rule, if you are paying your signature on a document, you are bound by that signature. Something similar under the parole evidence rule. However, we are saying that you cannot vary, contradict, subtract, add anything for as long as your agreement or terms have been reduced into writing. However, before I go to there, still, the Evidence Act tells you that the only thing that can change that document, that the terms you have put to writing, is the document itself. So there is nothing you are thinking about. However, as we have discussed previously, that every general rule has exceptions. Now, we have exceptions where oral evidence can be admissible into that document that you have reduced into writing. So oral evidence can be admissible. Now, what are those terms? How oral evidence can be admissible to what you have reduced into writing? The Act provides that where you have vitiating factors, and this I mean fraud, misrepresentation, then lack of capacity, lack of consideration, where you have those elements in a document you have written, when one of those elements surfaces, you can alter what you have written. Because remember, you can only contract with somebody who has capacity. If somebody mispresents, induces you to enter into an agreement which is misrepresentation or fraud, then we can alter. So the first exception where oral evidence can be admissible into the written document is where we have vitiating factors, where we have existence of vitiating factors. And under vitiating factors, I mean where there is fraud, where there is misrepresentation, where there is mistake of fact or mistake of law, where there is a lack of capacity, where there is lack of consideration. When those vitiating factors show up, then the written document can be put aside. Okay? Then we cross to the other one, that all evidence can be administered just to follow the trade or the custom of an area. That in this area, this is how we do it. So if in your agreement, you did not respect the customs, the areas of the place, then we can include all evidence depending on the customs and the trade customs of that particular area. For example, you may reach an area where they say, for us here, we only sell land at night. And it is a custom which is known in the whole area. So if you sell during the day and you reduce in writing, court will say, but the custom is in that area, they never sell land during the day. So you made a mistake, we can add this. I'm trying to just show you what we mean by custom. That in our area we do this. I remember the land council senior Bachide is one who taught us contract. The land council Bachide would say that in Chikubo, you have a custom that you come, I give you 100 millions, you go, you use, you bring back in the evening. It's a common thing used in Chikubo. It's a custom, common things we use in there. So, where a contract is made in Chikubo and it doesn't capture that usage, that trade, that custom that you normally use there, so courts can use that to include. You can say, no, but for us normally, this is how we operate. Even if you go and inquire from everybody. So court will listen. If it is a custom, if it is a usage, if it is a trade custom, a usage, court will use that to include all evidence into the written document which you earlier reduced. 2, if the contract was signed in 2 ways, partly written and partly oral, you can decide to have your document, you say it will be partly written and partly oral. So you have now written. The oral part is not there. So courts can get that oral part and include it in the written agreement. Because your intention earlier was, we have partly written and partly oral. Okay? That is the other scenario where courts can administer oral evidence into what we called the already written document. If the document is silent about the part covered by the oral evidence, that you may make a document, but it is quiet about the things you agreed on orally. So you tell the court, but in that document, there are things we agreed orally and are not there. So where the document is silent about the oral evidence, then court will get that oral evidence and include it inside there. Hope we are together. So those are some of the formats. I think there is another one. Oral evidence may also be where the written contract appears ambiguous and defective. If the oral evidence appears to be ambiguous and defective, then courts can include in oral evidence, because the written appears ambiguous. It is unheard of. Your requests in there are too big, so court may be forced, if the written argument appears to be defective and ambiguous, court may be forced to include oral evidence in that document. Hope we are clear about the parole evidence rule. There is another one I wanted to put emphasis on. Yes. Where the written contract does not represent the purpose for which the parties intended to rely on. If that written document does not represent the purpose, does not show the intentions of the parties who signed it, then court can administer oral evidence, and they include oral evidence into the written document. So those are some of the exceptions to the parole evidence rule. We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Until next time.